To the members of the Justice Committee, I come before you to address the current position on the special measures available for vulnerable defendants in our justice system, specifically to present reforms in the area that properly consider the principles of evidence, ensure the abiding of Article 6 of the European Convention on Human Rights, and ultimately make improvements to the principle of orality. The principle of orality is the presentation of oral evidence, which is a fundamental aspect of the adversarial system operated in England and Wales. This system favours the presumption of innocence and the presentation of evidence by two parties before an impartial judge. The special measures available for both defendants and witnesses are outlined in the Youth Justice and Criminal Evidence Act 1999. The measures available differ significantly for both parties, and it is my proposal that amendments should be made to treat vulnerable people in the criminal justice system the same where possible. It is also crucial that vulnerable people can be appropriately advocated for, and that such vulnerabilities can be identified and considered to ensure a fair trial for all involved through appropriate training for judges and police officers. Special measures refer to the varying of court procedures and methods for vulnerable parties and witnesses that appear before the court, to better their participation in court proceedings. As stated in the Civil Procedure Rules, Section 1, Subsection A, Paragraph 3, a person may be considered vulnerable due to an array of personal or situational, permanent or temporary factors that may adversely affect their participation in the proceedings. An example of a special measure in use is in Section 23, Subsection 1 of the YJCEA Act, which provides that witnesses can be screened from seeing the accused in proceedings. This is used in cases such as involving sexual violence, domestic violence, to ensure that the witness's vulnerability does not prevent them from providing their best evidence. The Code of Practice, which acts as a guideline for trial judges when dealing with these particulars, goes on in Section 4 to reference the various factors that will deem someone as vulnerable. These include things such as age, mental or physical impairment, mental health conditions, language difficulties, and so on. While these vulnerabilities are recognised and respected in regard to witnesses, the law currently fails to acknowledge and to a degree has actively excluded special measures for vulnerable defendants. Samantha Fairclough identified the reason for such an omission in her article, stating that defendants were excluded due to the 1998 Speaking Up for Justice report by the Home Office. That report concluded that defendants' rights to fair trials and any vulnerabilities they had were adequately protected by current safeguards in the interview stage and in trial. Specific mention was made of the current right to legal representation and appropriate adults during the early stages of investigation and trial. The Act specifically omits defendants from various protections based on the incorrect conclusion that the sole purpose of special measures is to protect the witness from the defendant, and thus it would be a redundant exercise to provide those special measures to the accused. However, this fails to identify the vulnerabilities of the defendant, potentially preventing them from actively participating in their trial, thus breaching the Article 6 right that one is entitled to. Fairclough states that these vulnerabilities can include things such as communication difficulties, problems speaking in public due to anxiety and fear, and more. Defendants only have one special measure available to them from the statute, being the use of live links for accused who meet the necessary criteria. However, this is the only mention of special measures for defendants within the statute. This means that defendants are essentially precluded from the statute. However, common law provides a sort of loophole for young offenders under the age of 18 who are witnesses in their own trial. Chu highlights that the provisions pertaining to live links in the YJCEA Act do not apply to defendants, but common law has interpreted necessary exceptions. In R.S. and Walton Forest Youth Court, the court confirmed that certain special measures, in this instance screens, could be afforded to child defendants who are inherently vulnerable on the basis that they could be intimidated and thus the appellant's ability to testify could be hindered. The trial judge refrained from outlining a firm eligibility criterion, but stated that the purpose is to ensure that the defendant can effectively participate in their trial and give their best evidence. Similarly, the decision by the European Court in the International Human Rights case of T&UK ruled that child defendants on trial for murder should be presumed to be unable to effectively participate in their trial due to the formalities of a courtroom. In this instance, the trial judge ordered for the removal of wigs and gowns and for a closure of the courtroom from the public during the child's testimony. Again, in SC and UK, the court found that there was a present breach of Article 6 rights, as the defendant in this case had little comprehension of the role of the jury, difficulty grasping the risk of a custodial sentence, appeared confused, and was failing to understand the effect of the trial, as discussed by Chu. Here, it is ever so clear that the accused should have been accorded special measures for his undeniable vulnerability as a child defendant. The common law exceptions highlight the issues of limited availability and insufficient protections in the Act and allow judges and magistrates to employ the common law where necessary. Thus, it is my submission that the common law should be codified into legislation in order to apply to both young and vulnerable adult offenders and to protect the discretion of the judge. Laura Hiono proposes in her 2015 article that the English and Wales legal system should follow Scottish suit, in that all special measures available to the prosecution should also be accorded to defendants, as a direct link to their Article 6 rights. Thus, my second submission is that the Act should be amended to protect both parties in a trial equally, where it is appropriate to do so. The Act provides that the prosecution, witnesses and victims a vast variety of measures to employ, such as the use of screens, giving evidence remotely by video conference, hearing evidence in private, dispensing of the formalities of the court, pre-recorded video evidence, and more. It is obvious that some of these measures do not make sense for the defendant due to their role in the trial. The argument that is often used to dismiss the use of special measures for defendants as a whole is that they are seen throughout the trial, so to remove them or to provide a screen only when giving their evidence is not a strong tactical choice and it may end up confusing the jury. This is explained by Fairclough. She goes on to discuss the use of such measures in Crown Court trials, providing many other arguments against treating witnesses and defendants the same, and for the low uptake of special measures by defence lawyers. Notably, a defendant's attendance is not going to be affected by the placement of these measures. They have to attend court regardless, opposed to a witness, where the measures might be used to induce them to attend court. Fairclough also discusses that while there is a presumption of innocence in the adversarial system, there is an underlying attitude that if someone has managed to end up as a defendant in a serious crime, they cannot be that vulnerable. However, to accept this attitude in legislation cannot be tolerated. It goes against the fundamental aspects of trials in this country, as well as international human rights, and reform needs to be made. As aforementioned, defendants can suffer from a variety of vulnerabilities, and they must be treated as individuals with individual characteristics and not as checklists, states Hoyana. Hoyana calls for case-by-case determinations, as no two defendants are the same, in the same way that no two witnesses are the same. The current position only protects defendants by the sensitivity and common sense employed by individuals within the justice system, not by protocols. However, even if adequate protections and measures were amended into legislation, it still needs to be appropriately identified by judges, officers, and lawyers for them to be considered. While it is commonly thought that it is up to the defendant's legal representation to identify their vulnerabilities, it is ultimately up to the judge as to how they will be treated during the trial. Similarly, in the investigation and questioning process before court, it is up to the police to identify such vulnerabilities. For example, in Aaron Cox, it was noted that when considering the use of intermediaries, it is up to the judge to determine if an absence of an intermediary would result in an unfair trial. This calls for an understanding of the vulnerability asserted, and for the effects the absence or presence this measure would have on the defendant. Fairclough discusses the importance of extensive mandatory training for legal professionals regarding defendant vulnerability and support, one that expands upon training for witnesses, as the situation and the role in trial are entirely different for each party. It should also extend to intermediaries, as they need to be trained in the specific needs of that defendant, and Hoyano states this training should be part of their professional accreditation and discipline, as it is for prosecution witnesses. Such specific training would ensure that defendants are treated with the sensitivity and understanding they deserve, as well as ensuring that attitudes that are in direct conflict with the presumption of innocence are not pandered to. To conclude, defendants and witnesses' vulnerabilities should both be recognised and considered during criminal trials, not only to ensure just outcomes, but to consider their Article 6 rights, provide the best evidence, and adhere to the adversarial system. This can be done through appropriate amendments and improved mandatory training that allow for the identification, consideration, and protection of vulnerabilities in defendants. Thank you for your time.